Yeah, that's a great question, actually. I think in some ways there's a balance between being a good, well versed, well prepared opponent and being a nice opponent. And I don't think that these are mutually exclusive or that they're necessarily things um, that are contradictory, right? So you'll often hear people say that certain trial lawyers are feared. I would say certainly that certain trial lawyers um, like to hear that, and certainly it's something that I've heard about myself a few times from clients, and I found it horrifying, to be frank, um, because first, what we do is not to scare people, but more importantly, I don't think it conveys well the reputation that I try to have and the reputation that I think um, tends to serve trial lawyers over time. So there's a positive aspect to that, to the extent that it means that you have a reputation as someone who's well prepared. And I think that that's a reputation that I try to cultivate, and hopefully one that I have with opposing counsel and judges, is someone who is always extremely prepared when I step into a courtroom. And I don't think I'm good because I am smarter, because I know more law. I think I'm good because I'm more prepared. And I know my exhibits in and out, my file, my witnesses. And so that tends to translate into favorable results for clients. It's a good reputation to have, but it's also one that you cultivate with a great deal of humility, because the basis for that is that every single time that you take on a case, it doesn't matter what you know, and it doesn't matter what reputation you have, right? You approach it with the same commitment and the same humility, and you over prepare, and you never have undue confidence in your abilities. That's a good thing for obvious reasons, and it's an attribute that tends to favor clients. So to the extent that's true, that my opponents know that, right, they're more likely to settle. And that's what we do most of the time, right? Maybe 70 or 80% of our files get settled, which is a very good thing. And usually I would say, as a general rule, tends to be easier for clients overall to live with the settlements that they entered into than the judgments that they had. So over the course of their, say, business career, right, overall, they'll probably be happier with the settlements that they entered into than the judgments that they had for or against them, for a bunch of reasons we probably shouldn't get into. My opponents are more likely to settle if they know that if they go to trial, they're in for a good fight, that I'll be prepared, and that I'll present my client's case in the best possible light. That does not mean that you have to be aggressive. I don't think being aggressive works. I'd say the foundational rule, in the way I've put it for my clients, the few times where I've been asked to take stances that I did not agree with, is that if people don't like you, they won't talk to you. And if they won't talk to you, they sure won't settle with you. So being aggressive is not fun. Certainly not fun for me. I know I might have certain opponents who find that fun, but it's not fun for me. I don't think it's fun for the majority of lawyers. It's certainly not fun for the person on the other side, And more importantly, it's not good for your client because it does not favor the perspective of a settlement if you are disliked by your opponent and by the counterparty. So I think I have, and I think most commercial trial lawyers have, a great reputation as people who are just nice. And I have opponents that I go up against repeatedly that I know personally, that have become friends over the years. I know about their lives, their careers, I know about their families, and we advocate very strongly on behalf of our clients. We take reasonable possessions, but we hold them when we don't think it's appropriate to settle for less. We do that both inside and outside of the courtroom. What we don't do is be rude to each other. And we get along, we talk about personal stuff, and that makes it much easier and more likely for your client to get a settlement because the other side's willing to come to the table, and when they do, right, you're not belittling them or making them feel horrible. So being aggressive, I guess, to answer the initial question, is generally not a good thing. It's a good thing insofar as it means that you are prepared, that you approach every case with the requisite humility. And it's not a good thing to the extent that it means that your approach in doing that is aggressive, and that you convey that in a way that's aggressive.